All right, counsel, before we pick the jury in, bring the jury in, with regard to the application by the defense for the admission of certain statements made by, purportedly made by the defendant, with regard to his lack of memory, the defense seeks to include that in the jury charge under pursuant to Rule 803C3. After reviewing that rule and my notes over the break, I am going to exclude that from the jury charge. I don't think it should be included for the following reasons. Number one, the statements were admitted as they pertain to the defendant's state of mind, which clearly is an issue in this case. And they were admitted only for that reason, not as substantive evidence. Now the defense is seeking to have them included as substantive evidence by including them in the section of the charge that deals with statements of the defendant. There's a separate section that deals with hearsay statements of a defendant admitted for the purposes of the psychological examinations and expert testimony as it pertains to insanity. As I understand it, the defense now seeks to introduce those substantively as proof that the defendant did not, in fact, remember the incident from his own mouth. However, that request to treat this evidence now as substantive evidence comes after the close of the evidence in the case. That application, if they wanted to treat it as substantive evidence, they should have made that application before the close of evidence, not as part of the jury charge. That's the first reason. The second reason I'm not including it as part of the jury charge is because under that rule, in order for the court to admit it, I have to find as a condition precedent to admissibility that the statements offered were, quote, made in good faith. And that's supposed to be a determination by the court prior to admission under Rule 104A. However, whether that statement was made in good faith is an issue for the jury to decide in this case. Expert testimony was introduced regarding the defendant's alleged loss of memory and the reasons for it. And the state expert testified that the defendant may have feigned amnesia, that is, that he was malingering his amnesia. Whether the defendant has a memory loss, can't remember the incident, or is malingering is an issue for the jury to decide. So if that's an issue for the jury, I don't see how I can find now that that statement was one that was made in good faith by the defendant based on the testimony. Or it's excludable for that reason as well. And finally, the third reason is that that Rule 803, the exception, I should say, to the hearsay rule, 803C3, specifically excludes, quote, a statement of memory or belief to prove the fact remembered or believed. This is the point Mr. Schellhorn raised. And here it's a little unique because the statement isn't one of memory, but a loss of memory. But the statement holds true. The defense is now seeking to introduce that substantively, a statement regarding memory, in this case a loss of memory, to prove the fact that the defendant can't remember the incident. And that's not allowable under the rule. So I will not include it in that section of the jury charge. Now what is relevant in that section of the jury charge, and I make reference to it, is there's testimony, and this is what I say in the charge in this portion. There was also testimony adduced from various witnesses regarding the defendant's physical injuries and mental status at the time the statements were purportedly made. That's the issue. Because this whole section deals with the credibility of the statement, when it was made, what the circumstances are. And the jury's instructed, you should take into consideration the circumstances and facts as to how the statements were made, as well as other evidence in this case relating to the issue. And it instructs a jury, if after consideration of all these factors you determine the statements were not actually made or that the statements are not credible, then you must disregard the statements completely. So the circumstances of when they were made is something that is significant in the case, and that's why I include that reference to testimony of various witnesses regarding physical injuries and mental status at the time the statements were purportedly made. That draws the jury's attention to something they'd have to consider when they consider those statements, such as what Corporal Heimer said. Officer Wurtenberg made some descriptions of his mental state, Detective Gould as well, Jason Hensley, and then Vitale, Held, and Dr. Haney all made statements in that regard. I think those are somewhat too difficult to mention in detail because there's a lot on direct and cross, and to give a fair assertion of it, I'd have to go into significant detail about what was said. My intent, unless I hear an objection, would be just to draw the jury's attention to those witnesses who commented on the physical and mental condition of the defendant at the scene or at the hospital. Do you have any objection if I do that without getting into the detail?
No, I agree with that, Your Honor.
Counsel?
I understand Your Honor's ruling, and I accept it.
Right. So I'll just mention the names, and I went through all my notes. I'm not going to say these are the only witnesses. I'm going to say including the following. Because I'm not going to tell the jury what they can and cannot consider. I'm going to draw their attention to these because these are reflected in my notes, but I'm not going to get into the specifics of what they said.
Yes, Your Honor.
All right?
Your Honor, I did want to just mark as a proffer Exhibit 10 of today's date, which are the materials they sent over about proposed changes to the jury charge, just so they have it in the record. Thank you.
All right, let's bring the jury in.